Due Process, recipient of 6 Mid-Atlantic Emmy Awards.
A federal appeals court says no to Under God. The Supreme Court says yes to the 3 strikes law and to Megan's law on the internet. Major court decisions prompt this special edition of Due Process.
Major funding for Due Process is made possible by the New Jersey State Bar Foundation, committed to educating the public about the law. Additional funding is provided by Lawyer's Diary and Manual.
They are among our most controversial laws. Both were designed to combat serious crime. Both became law here in New Jersey and across the country in reaction to monstrous sex assault murders of children by repeat offenders. And both were upheld this week by a sharply divided United States Supreme Court.
One of those decisions gives the court's green light to Megan's Law, which began here in New Jersey but has swept all 50 states. The other affirms the notion of 3 strikes and you're in for life, even for crimes that may not be violent felonies. Both of them controversial provisions that we've been following closely for years.
So when the High Court finally acted on both, we made the call to postpone our planned show on street surveillance cameras in order to bring you this special edition of Due Process. I'm Raymond Brown, here with Sandy King and 2 guests who've been intimately involved on opposing sides with these controversial criminal laws. For Michael Patrick Carroll, it's been as an assemblyman and lawyer who supports New Jersey's version of both Megan's Law and 3 strikes. For Frank Askin, professor of constitutional law and author of Defending Rights, A Life in Law and Politics, it's been as national counsel to the ACLU, which has led the fight against both measures.
We'll hear why the court was right, why it was wrong, and what it all means for us here in New Jersey. And we'll get their divergent views of still another controversial decision, this one from a federal appeals court in California. The subject, the Pledge of Allegiance, and the words, under God. But we begin with Megan's Law and a portion of a report we did 3 years ago when New Jersey was first considering putting Megan's Law offenders on the internet.
How can you live in a community like that? It's never going to be kept a secret, even though it says it will be.
We first met this convicted sex offender 4 years ago. His fear back then that he'd be disgraced and damaged by the new legislation known as Megan's Law.
I just don't think it's fair to a lot of people.
Today, he says he's too afraid to talk to us at all, with the impact of Megan's Law about to be electronically stepped up.
When you're marked with a scarlet letter, your entire community knows that you're a former offender, you fear vigilantism, and you're trying to move forward with your life, it's very difficult to establish that stability and move forward as a law-abiding citizen.
But Megan's Law so far has survived its court challenges. And the idea that began right here in New Jersey with the shocking murder-rape of a 7-year-old girl by an ex-con neighbor with a violent, hidden history as a sexual predator has now led to Megan's Laws in all 50 states.
I mean, we represent people. Right. They're demanding that we take action in this area. They're demanding that they have the greatest sense of security in this area, and we want to provide that.
Their plan to follow the lead of 15 other states by taking those confidential records, now confined to those likely to encounter, and putting them on the internet for everyone to see.
I'm afraid that these notification policies will push offenders underground and make them more likely to offend as a result of that.
The legislature has been with us on this, and I know there are strong feelings there to ensure that we give the citizens in our communities the tools that they need to ensure their own safety.
That tool would mean that a John Doe like this one, whom we met 2 years ago when a neighbor leaked this confidential communication to a local paper, would have his name, face, address, and more on an official state website like this one from Florida. As for our initial John Doe interview, he had been convicted of molesting 2 little boys. Still, his designation was and is Tier 1. Till now, that meant only confidential registry with local police, but no community notification. The Internet plan would change that too.
There is a 14th Amendment due process right to privacy. You're entitled to due process under the law. You're entitled to some protection of your reputation. You cannot be publicly branded, at least not since the Salem witch trials were dispensed with, and placed in the stocks in a public square.
So just what happened in the Supreme Court last week? Well, New Jersey was never mentioned. The cases that were ruled on were from Alaska and Connecticut. But the decisions that Megan's Law, even on the net, is not second punishment for the same crime, and that Megan's Law does not constitute public branding, could have broad implications for all the states, including New Jersey.
Frank Askin, we know 2 things. One is that in the criminal arena, the legislature can do pretty much what it wants to as long as it doesn't exceed constitutional limits, and that there have been almost a decade of constitutional challenges to Megan's Law and the other laws like it. Do these 2 rulings by the United States Supreme Court, in your view, bring that constitutional challenge era to a close, or are there other issues that can be explored constitutionally?
Well, there were a few other issues involving personal privacy, and it's just how much information can be divulged over the internet on persons who really have no indication of dangerousness, no reason to think they're a continuing danger. But I think most of the major issues have been decided now. I think the important one was the ex post facto decision. The court's, I find, rather astounding decision that you can brand a person with a scarlet letter for life, but it is not even for events that they committed prior to the passage of the act. But that is not punishment. It's not criminal punishment. I found that decision astounding.
So, Professor, does that mean that the ACLU now drops all of its challenges to Megan's Law here in New Jersey?
Well, no, they'll have to drop the challenge to the ex post facto application of it, but there are still some remaining issues dealing with exactly how much information can be put on the, for example, the issue before the Court of Appeals in Philadelphia now is whether addresses of persons can be put on the internet, or whether they may be limited to those with a need to know. That's the next big issue in the New Jersey Megan's Law litigation. And it's certainly possible the legislature will try to even expand the current Megan's Law beyond its current boundaries.
Which brings us to my next question to Assemblyman Carroll. The green light is definitely on for New Jersey and all of the states. Will the legislature now move ahead and make our Megan's Law, which is actually less aggressive than either Alaska or Connecticut, more aggressive, and how do you see that going, and when?
There's 3 predictions in there. That's very difficult to predict what the legislature is ever going to do. And as Professor Askin would certainly say, I'm sure, that just because the federal Supreme Court has said that we can do something doesn't mean our New Jersey Supreme Court would necessarily agree.
That's true.
I don't know of any legislation which has been introduced to that effect, and I wouldn't want to predict on its potential outcome.
Let me focus on the hearing question. One of the things New Jersey does is create certain rights to hearings. In the Connecticut case in particular, the Supreme Court is saying that right may not be a question of constitutional right. Any chance the legislature might reconsider the hearings that are given in New Jersey?
There's always that chance, but as you know, our particular statute limits the people who are on the internet, I think, to Tier 1 or whatever it was.
And 2.
Tier 1 and Tier 2, but it doesn't, the people who are, quote, less dangerous, unquote, are not required to be on or not permitted to be on the net. I think our Supreme Court has already passed on that subject. They said that the law is constitutional as written, but they've played some, I think they performed some surgery on the law the last time. I don't know that there's any legislative move to go any further at this juncture.
Let me ask Frank the same question. Frank, on the dangerousness question, in Connecticut, Justice Rehnquist seemed to be saying by putting somebody's picture on the internet and indicating that they've been a child molester, that we're not saying that person is dangerous. Was there something wrong in my reading of the opinion, or is that what the court's saying?
Well, I believe in Connecticut they actually have a disclaimer that we do not say that any of these people are dangerous, and the U.S. Supreme Court said that was sufficient. Without that disclaimer, the suggestion that they are dangerous, I think, might change that result, and I think certainly would change it in New Jersey. I think our Supreme Court has made it clear that there is a right to a hearing, I believe under the state constitution, of potential dangerousness.
But hearings aside, Assemblyman Carroll, are we not saying when we say 1 and 2 are more something and therefore on the internet, and 3 are less something, aren't we talking about dangerousness? Is there something disingenuous about the Chief Justice's words here?
Well, Chief Justice Rehnquist, no. I mean, it was a very specific legalistic determination where Connecticut didn't draw a distinction. It just simply said everybody goes on the web one way or the other. And the question was whether or not that in and of itself was a violation of the due process clause, whether there was a liberty interest in having a hearing before you were put on the web. And I think the court said, given the way the statute is written, there is no such interest. I don't think that applies here in New Jersey.
Our 3 tiers will remain?
I don't see any way that there won't. I mean, again, our New Jersey Supreme Court has already passed on that question.
And our 3rd tier people will remain off the internet?
At least for the time being, sure.
Am I wrong? Is it the other way around? Is it tier 3 that are the most dangerous? Maybe
I think you're probably right.
I think it's tier 3 that are the most dangerous. They're the ones that go on the internet.
Sandy, I think that brings us to some other activity by the Supreme Court. Its other big bomb exploded efforts to derail the 3 strikes laws. They swept New Jersey and a majority of states in the mid-90s following the kidnapped murder of 12-year-old Polly Klaas in California. But California's courts have applied 3 strikes in a really broad way. It was a sentence of 25 years to life for a repeat offender who stole 3 golf clubs, and of 50 years to life for another petty thief who stole $150 worth of videos that prompted the High Court, which said that even those examples of 3 strikes were not cruel and unusual.
It means New Jersey's less severe 3 strikes law is almost surely safe from constitutional challenge. And it means bad news for New Jersey's 3 strikes lifers, like Kevin Paulk, whom we met in Trenton State Prison about 3 years ago.
I thought that the 3 strikes law was for heinous crimes, crimes of murder, crimes that involve serious violence, things like that.
So when did you find out that you were going to come under 3 strikes?
When I went to the courtroom, the prosecutor stood up and said that we're seeking 3 strikes for this gentleman.
And 3 strikes was what he got. A sentence that says he'll stay in this place at least until he's 70 years old. That's 35 years or more locked up.
The prosecutor, she was so overzealous. She was sashaying back and forth, like, you know, like she had like Hannibal the cannibal sitting there.
And she was successful. Kevin Paulk became one of the handful of New Jersey inmates to feel the brunt of the Persistent Offender Accountability Act. 3 strikes and you're in for life.
Burglary, robbery. It's all been burglary, robbery.
That's it.
No violence.
No violence.
No assault.
No assault. Never.
Paulk insists he has never been violent, and despite a long record of small-time robberies, his record confirms he has no history of causing any physical injury. But he did use toy guns in his holdups, and the law says that's all it takes to classify him as a menace to society, a violent repeat felon, toy gun or not.
What difference does it make? When someone comes up to you with a gun, how do you know whether it's a real gun or not? We've experienced that with our police department. Somebody points a gun at you, it's a gun.
So you'd say that's an appropriate sentence?
Absolutely. Absolutely. Don't commit that crime.
My record says that I'm not a vicious, violent felon because I don't have any vicious, violent crimes. Don't.
You're still in here for life.
Yes, I am. There are people walking in and out of these places after killing people, after raping and sodomizing little boys and little girls. I've seen it. I mean, I'm in this place with people who have committed heinous crimes. Now, there's no way in the world that a man like me should be sitting in this place for the rest of my life for the crimes I committed. There's just no way.
But in the even more dramatic California cases, the court, despite 4 dissenting votes, rejected the claim that those life sentences for relatively minor property crimes were so grossly disproportionate as to violate the 8th Amendment.
In writing the opinion, Justice Sandra Day O'Connor made it clear that the majority was not anxious to set aside state sentences or usurp legislative prerogatives. In her words, we do not sit as a super legislature to second-guess their policy choices. And Assemblyman, you're nodding your head. You liked that.
Well, I like the idea that some court somewhere recognizes that it's not a legislature.
As opposed to our court?
Well, opposed to our Supreme Court, which seems to be perpetually acting like a legislature. I want to take one issue with something you said very ago, was it was the courts that had taken a broad stance in California. It's not the courts necessarily, it's the legislature. They wrote a very broad law. And the question that was presented to the Supreme Court was, does this violate the Eighth Amendment?
Right, and if we ask you to take off your assembly hat and put on your lawyer hat, you do recognize that the courts have to set the outer parameters to what's permissible.
In theory, yes, but the fact of the matter is
only in theory.
Well, in theory, yes, because the fact of the matter is that the Eighth Amendment says that only cruel and unusual punishments are prohibited. And the one thing I found lacking in any of the dissents in that case was a statement as to what the framers intended when they wrote that word. Now, you and I had a discussion before. The two leading cases on this subject are basically 80s and 90s cases. If you want to convince this originalist that something violates the Eighth Amendment, you better be able to prove to me what James Madison had to say about the Eighth Amendment and what constitutes cruel and unusual punishment.
Professor Frank, let me bring you in on this because I suspect that 25 and 50 years respectively for the crimes that we've outlined does strike you as cruel and unusual?
Well, as an originalist and strict constructionist, it's hard for me to imagine what's cruel and unusual if it's not 50 years in jail for stealing a couple of videotapes. I don't know what's left of cruel and unusual. I guess if it were the death penalty, I guess that would be cruel and unusual.
Well, in the early days of the common law, Professor, they didn't have videotapes. But let me ask you this. Can you tell us what this idea of proportionality means?
Well, I'm not sure it means anything anymore after the latest decision.
What did it mean before this, when you were teaching your class last year?
It has to do with consistency and deviation. I mean, if you're convicted of 3 crimes, each one of which is worth 1 year in prison, it's a little out of whack to say, well, for the 3rd crime, instead of 1 year, you get 25 years or 50 years or life or what have you. That's disproportionate. It's totally inconsistent. It deviates from anything else in the criminal law. But as I say, after this decision, I don't think it has any constitutional meaning whatsoever.
Assemblyman, the reaction, I think, to the sentences in California tended to be, even among people who consider themselves law and order people, oh, you get any of that? Do you feel any sort of sympathy for these poor fellas who, in fact, for crimes that would have drawn short sentences elsewhere or previously, now are looking at the rest of their lives in jail?
Sure. I mean, I don't think anybody could possibly feel anything but a little bit of sympathy for them. I mean, again, these were, as Professor Askin has said, relatively minor offenses. But what the guy's name was, Ewing, I think it was, he's a professional pest. I mean, this guy has a rap sheet as long as your arm. And it's not just
but life in prison for a professional pest?
You know, the answer to the question is would I make that determination if I were in the legislature and asked to pass on that? Probably not. But the legislature in California made that call.
But let me ask you about what you said earlier, because I want to challenge your originalist idea. In the early days of the common law, where the antecedents of our Eighth Amendment lie, children were executed for theft. Clearly, you don't think that those are the standards which should govern whether the court says at some point there's got to be a limit on punishment.
I would find it very difficult to believe that in 1789 or 1791 that children were executed for theft
But the law would have provided that in England, certainly.
Maybe, but then again, we're talking about the American Constitution now. And the question is what did the people who wrote and ratified that amendment mean when they wrote those words? If I'm sitting on the bench and now been endowed by the Senate, the President of the Senate with a black robe, and you say...
For life.
For life, or for 7 years here in New Jersey with the option to renew. If you say to me, the constitutional language here means something, I want to know what it is that it means and how it was that you came to that conclusion. And as I think Justice Scalia and Justice Thomas said, there is no proportionality provision written into the Eighth Amendment. It just doesn't exist. So I agree with Professor Askin in his present determination that it doesn't exist, and it shouldn't unless you can establish to me that the people who wrote it and drafted it and framed it and ratified it intended there to be one.
Frank Askin, chilling effect, you think, on criminal justice in this country, in this decision?
Well, I'm not sure what you mean by chilling effect. There's nothing wrong with chilling people from committing crimes. I suppose that's perfectly
Well, do you think this
appropriate.
works as a deterrent? That, after all, is the idea.
I'm sorry, I missed that.
Do you think that this works as a deterrent? That was, in fact, the idea of all these three strikes laws.
You know, I'd have to turn to the sociologists for that. I haven't done the studies as to what really deters people or not. I'm not sure. I'm skeptical that it has real deterrence, but I couldn't swear to it. But what it really does say is something about our society which tolerates this kind of really unjust treatment on somebody who maybe 3 times does some shoplifting and suddenly finds they're in prison for life at the age of 20 or 21. That really does seem to me to be pretty shocking.
And Kevin Paulk, whom we met in that package, you believe he stays in prison for the rest of his life as a result of this decision and the likelihood that therefore the challenge in New Jersey is just not going to mean much?
Well, no, I'm not so sure about that. The New Jersey Supreme Court has been pretty bold in differing with interpretation of the United States Supreme Court. We have our own cruel and unusual provision in the New Jersey Constitution, and it's certainly quite possible that the New Jersey Supreme Court will ultimately decide to interpret that differently than the U.S. Supreme Court has interpreted the Eighth Amendment.
Intriguing as this is, Sandy, let's get to the pledge. The 3 strikes ruling took the Ninth Circuit Court of Appeals to task. The Ninth Circuit had overturned that 50 years to life sentence. But the appeals court was itself overturned, and that's what some court watchers are hoping will happen when the High Court finally looks at the Pledge of Allegiance, because the Ninth Circuit has refused to reconsider its ruling that the words "under God" made the pledge unconstitutional. Sandy filed this report when the court first ruled.
One nation under God.
I think they should leave it alone. First of all, you know, it was written that way. I don't think you should change things that have always worked.
Well, actually, it was not written that way back in 1892.
The original version of the Pledge of Allegiance said it perfectly. One nation, indivisible, with liberty and justice for all. There's nothing more American than that.
In fact, it would be 62 years before the words "under God" were inserted at the height of the Cold War.
It was supposed to be an attempt to separate America from godless communism.
And among the sponsors, Newark Congressman Peter Rodino, who last year by phone maintained the words were not really religious.
The words "under God" were used, I believe, in a symbolic sense.
It was done for a very particular reason. That reason was inherently religious, and the Constitution says that inherently religious things ought not be part of what our public government makes us do.
I pledge allegiance to the flag of the United States of America.
At this time, when everyone's still in mourning from what happened, they're going to touch the Pledge of Allegiance like that.
And given the times, even supporters of the Ninth Circuit ruling concede it is unlikely that "under God" is going anywhere.
I don't think it will survive a Supreme Court test. The Supreme Court has passed "In God We Trust" on our coins as being a non-religious statement.
That doesn't mean that another court, some other day, reconstituted with justices who have different political beliefs, won't go a different way. But I think that it's inevitable that with this court, the decision will be reversed.
Well, the question now is whether the Supreme Court is going to hear this matter. Frank Askin, the Supreme Court has to give permission for a matter to come before it. Is the Supreme Court going to grant cert and wrestle with this important but somewhat symbolic issue?
Well, if I were a betting man, I guess I'd say yes. Although, you know, first of all, I think the Ninth Circuit opinion is eminently sound and reasonable.
So that means not only will the court consider it, but they'll rule to affirm the court?
Well, if they take it, they're not going to affirm. Maybe they'll reject it. Maybe Justice O'Connor will be a little ambivalent about it, and maybe she'll get some other supporters to say, well, let's not take it, or let's set it aside on technical standing ground. The fact is, this is different than the motto on our coins. This is coercion of school children. As President Eisenhower said when he signed the bill into law in 1956, from now on, millions of children every day will be compelled to stand and pledge their allegiance to the Almighty. If that's not an establishment of religion, I don't know what is. I think the Ninth Circuit was absolutely right as well as courageous. And I don't know, maybe there aren't, maybe Justice O'Connor, maybe Justice Kennedy will have some second thoughts before they decide that they ought to overrule that.
Frank Askin, you just drew some laughter from Assemblyman Carroll. What's so funny?
Well, nothing's funny, I suppose. I'm loath to predict these things, but I think about 2 years ago, the Ninth Circuit was the subject of 22 separate United States Supreme Court decisions, and they were reversed in 21 of them.
Right, but back to under God, you were, when Frank was making his arguments why this was establishment of religion, why it was unconstitutional, you were laughing.
Well, yeah,
you don't think those arguments make sense?
No, I don't think it. I think it's pretty silly to assert that this is somehow an establishment of religion. The whole point of the First Amendment was to prevent a national or state, or at least in theory, state churches. The idea that we have somehow endowed the schoolhouses with a state religion is pretty far-fetched.
But you will concede that it's more likely that the court would wrestle with an issue that involves children than, for example, whether there's prayer in a legislature or conduct that takes place among adults.
Well, certainly they've done that in the high school football cases and things along those lines. Yes, I think that's a reasonable statement.
So, Frank, up or down? Yes or no?
If I had to predict, I agree with the professor. I think that all likelihood they'll treat this as more or less a secular event, like In God We Trust in Our Coins.
Frank Askin, we heard Peter
Sandy,
Rodino's...
I don't think we have time for Frank Askin. I think that's it for this special due process court update. But we'll be back here next week with more on the courts and public policy and law. Till then, for Sandy King and all of us here at Due Process, I'm Raymond Brown. Thanks for watching.
Ready, boys and girls?
Yeah.
I
pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Major funding for Due Process was made possible by the New Jersey State Bar Foundation, committed to educating the public about the law. Additional funding was provided by Lawyer's Diary and Manual,